I'll call the next case. It's case number 65867, James Morris Balagia, which is a compulsory discipline matter. When we called the docket, Mr. Balagia wasn't here. I assume he has not arrived. Don't see him. So this case, would you like to proceed?
Yes, please.
And if things are going to be submitted into the record as exhibits, you don't necessarily need to read them or tell us the details of them, but if you could just summarize and get your exhibits in, that's probably sufficient for today.
I'm trying to go as slowly as possible. May it please the board. This is a compulsory discipline case based on Mr. Balagia's conviction for count 1, 18:1956H and A, conspiracy to commit money laundering. Count 2, 18:1503, 1503B3, obstruction of justice and aiding and abetting. Count 3, 21:1904C2, 1906, conspire, endeavor, and attempt to violate the Kingpin Act. Count 4, 18:1349, 1343, conspiracy to commit wire fraud. And count 5, 18:371, conspiracy to obstruct justice in the United States District Court, Eastern District of Texas, Sherman Division. The petition for compulsory discipline was filed on September 10th, 2021. The first amended petition for compulsory discipline was filed on February 11th, 2022. Respondent was personally served with the first petition for compulsory discipline and notice of hearing by Deputy Dean Restilli, a deputy with the Howard County Sheriff's Office, on February 18th, 2022. Proof of service has been on file since February 28th, 2022. Bear with me on this procedural history. I'll try to do it again as fast and slowly as possible. Thank you. On or about February 9th, 2017, respondent was charged by superseding indictment with count 1 in violation of 18 U.S.C. 1956H, conspiracy to commit money laundering. Count 2 in violation of 18 U.S.C. 1503, and 2, obstruction of justice and aiding and abetting in cause number 4, 16 CR 176, styled United States of America versus Charles Norman Morgan, United States District Court, Eastern District of Texas, Sherman Division. On or about February 14th, 2018, respondent was charged by second superseding indictment with count 1 in violation of 18 U.S.C. 1956H, conspiracy to commit money laundering. Count 2 in violation of 18 U.S.C. 1503, and 2, obstruction of justice and aiding and abetting. Count 3 in violation of 18 U.S.C. 1512, B2D, and 2, attempting to tamper with and tampering with an informant and aiding and abetting. And count 4 in violation of 21 U.S.C. 1904, C2, conspiracy to violate the Kingpin Act, cause number 416 CR 176, styled United States of America versus Viviana Correa in the United States District Court for the Eastern District of Texas, Sherman Division. On or about May 10th, 2018, respondent was charged by a third superseding indictment with count 1 in violation 18 U.S.C. 1956H, conspiracy to commit money laundering. Count 2 in violation 18 U.S.C. 1503, and 2, obstruction of justice and aiding and abetting. Count 3 in violation of 21 U.S.C. 1904, C2. Conspire, endeavor, and attempt to violate the Kingpin Act. Count 4, in violation of 18 U.S.C. 1349. Conspiracy to commit wire fraud in violation of 18 U.S.C. 1343. Count 5, in violation of 18 U.S.C. 371. Conspiracy to obstruct justice in cause number 416 CR 176, styled United States of America versus James Morris Balagia in the United States District Court for the Eastern District of Texas, Sherman Division. On January 9th, 2019, respondent was charged by fourth superseding indictment with count.
Can we skip to the conviction? Is that the only relevant?
Sure. But they'll cut out one paragraph. Yes. On or about May 4th, 2021, a judgment in a criminal case was entered in 416 CR 00176-ALM-KPJ3, styled United States of America versus James Morris Balagia in the United States District Court for the Eastern District of Texas, Sherman Division, wherein respondent was found guilty of count 1, 18195-6H and A, conspiracy to commit money laundering, count 2, 1503, 1503B3, obstruction of justice and aiding and abetting, count 3, 1904C2, 1906, conspire, endeavor, and attempt to violate the Kingpin Act, count 4, 1349, 1343, conspiracy to commit wire fraud, and count 5, 18371, conspiracy to obstruct justice. Respondent was ordered to be committed. Respondent was committed to the custody of the United States Bureau of Prisons to be imprisoned for a total term of 188 months as to counts 1, 3, and 4, 120 months as to count 2, 60 months as to count 5. All terms to run concurrently. Upon release from imprisonment, the defendant will be on supervised release for a term of 3 years. This term consists of 3 years on each of counts 1 through 5. All such terms run concurrently. Respondent was further ordered to pay penalties of an assessment in the amount of $500. Respondent filed his notice of appeal to the United States Court of Appeals for the Fifth Circuit on May 4th, 2021. At this time, I'd like to offer the following exhibits. Exhibit 1, certified copy of the superseding indictment filed in the underlying criminal matter. Exhibit number 2, certified copy of the second superseding indictment filed in the underlying criminal matter. Exhibit number 3, a certified copy of the third superseding indictment filed in the underlying criminal matter. Exhibit number 4, a certified copy of the fourth superseding indictment filed in the underlying criminal matter. Exhibit number 5, a certified copy of the judgment in a criminal case filed in the underlying criminal matter. Exhibit 6, my original affidavit attesting to the fact that respondent is the same person as the person identified as a defendant in the underlying criminal case. And exhibit number 7, original certificate from Blake A. Hawthorne, Clerk of the Supreme Court of Texas, dated April 5th, 2022, indicating that respondent is licensed but not currently authorized to practice law in Texas. Exhibit 8, a certified copy of Mr. Balagia's prior disciplinary judgments. May those be entered at this time?
Yes, exhibits 1 through 8 are admitted. Yes.
At this time, petitioner seeks entry of an interlocutory order of suspension pending the outcome of Mr. Balagia's criminal appeal.
Thank you. We will take the matter under advisement.